When the Supreme Court steps into a fight that touches both the Second Amendment and the Fourth Amendment, it's not just another case. It's a constitutional showdown. This October 15th, the justices will hear Case versus Montana, a challenge that asks a question every American should care about. Can the government step into your home without a warrant, seize your firearms, and justify it later by calling it an emergency? This case doesn't come out of theory or law school hypotheticals. It started with a real-world encounter in Montana, where police entered a man's home, shots were fired, and a handgun was seized. And now, the ripple effects could shape how much protection your front door really gives you under the Constitution. So today, we're going to break down what happened in this case, why the lower courts leaned on shaky doctrines to excuse a warrantless entry, and what the Supreme Court might do next. Because, make no mistake, the ruling here could set the tone for how far the government can reach into your private life, your home, and yes, even your gun safe. In Montana, this case started like so many others, with a phone call. Trevor Case's ex-girlfriend phoned police, saying he'd threatened to harm himself, and even warned that if officers showed up at his home, he might harm them too. That kind of tip set the stage for what came next. When officers arrived, they didn't rush in right away. They spent nearly 40 minutes outside the home, looking through windows, shining flashlights, and even noticing an empty holster on a table. At one point, they talked about calling Trevor's father or trying his cell phone. But instead of those safer alternatives, they geared up with rifles and ballistic shields and walked straight through the unlocked front door, without a warrant. Once inside, the search split the team. 2 officers upstairs, 2 downstairs. In an upstairs bedroom, one officer saw a curtain move. Behind it was Case, and in that split second, the officer believed he saw a dark object. Shots were fired. Case was hit in the arm and stomach before being given medical treatment. During the search that followed, officers discovered a handgun tucked away in a laundry basket. That single piece of evidence is now at the center of this Supreme Court fight. Case's attorneys argue it should never have been admitted in court because the entire entry, from the moment the front door swung open, was unconstitutional. The lower courts didn't see it that way. A Montana court, in a narrow 4-3 decision, upheld the officers' actions under what's called the community caretaking doctrine. Essentially, they ruled that the officers had a reasonable suspicion of an emergency, and that was good enough to justify entering the home. But Case's legal team argues that's not how the Fourth Amendment works. The Constitution requires probable cause, a much higher bar than mere suspicion. And that's the tension that has now landed squarely before the 9 justices in Washington, D.C. To understand why Case versus Montana matters, we have to step back into the history of Fourth Amendment law. The Montana Supreme Court said officers acted lawfully under the so-called community caretaking doctrine, the idea that police can enter a home not to investigate a crime, but to protect someone's safety. That sounds reasonable on paper. But there's one big problem. The U.S. Supreme Court already dismantled that very doctrine in a case called Caniglia v. Strom back in 2021. In Caniglia, police seized firearms from a Rhode Island man's home after his wife reported he might harm himself. Officers claimed they were just looking out for the community. The justices didn't buy it. In a rare 9-0 unanimous decision, they ruled the community caretaking excuse does not apply inside the home. Why? Because the home holds the highest level of constitutional protection. If the police want in, they need either a warrant or a truly recognized exigent circumstance. That's why Montana's ruling looks so shaky. Case's lawyers argue there was no real exigency here. The officers had been outside for nearly 40 minutes, saw no active threat, and still chose to enter. That's not an emergency. That's impatience. And under Coniglia, the bar isn't suspicion, it's probable cause. Here's what makes this fight even more important. The Supreme Court hasn't revisited these issues since Coniglia. Lower courts across the country have been left guessing how far they can stretch exceptions. Some judges stick with the strict standard of probable cause. Others bend it toward reasonableness, as Montana did, creating a patchwork of rules that change depending on where you live. For gun owners, that's dangerous. Because if suspicion is enough to open your front door, then firearms inside your home could be seized on little more than a hunch. And that risk brings the Second Amendment and the Fourth Amendment into direct collision. Your right to keep arms versus the government's claimed power to take them without a warrant. This case isn't just about one man in Montana. It's about the standard every police officer in America will be held to when they face a choice: wait for a warrant or push through your front door. If the court sides with Montana, it lowers the bar for entry into your home from probable cause all the way down to reasonable suspicion. That may not sound like much of a difference, but in constitutional law, it's enormous. Think about what's at stake. Reasonable suspicion can be triggered by a tip, a phone call, or even a gut feeling. Probable cause requires evidence, real facts, that an emergency exists. If suspicion alone becomes enough to justify warrantless entry, then the Fourth Amendment's protection of the home is weakened in a way we haven't seen since the founding era. And when that entry leads to the discovery or seizure of firearms, it turns into a Second Amendment issue as well. Gun rights advocates see this as a double threat. Not only could your privacy be invaded without judicial oversight, but your firearms could be confiscated in the process, all without the constitutional safeguards the founders intended. That's why groups like Gun Owners of America and others have filed amicus briefs urging the Supreme Court to step in. They argue that the Montana Supreme Court didn't just stretch Coniglia, it ignored it, replacing a clear 9-0 ruling with their own watered-down standard. And let's not ignore the timing. With oral arguments scheduled for October 15th, this case is landing in a Supreme Court that has recently been more willing to enforce strict constitutional protections, from Bruin on the Second Amendment to Coniglia on the Fourth. If the justices choose to reaffirm those principles, they could set a bright-line rule. Warrantless entry into a home requires probable cause of a true emergency. No exceptions. On the other hand, if they uphold Montana's approach, it opens the door, literally, for law enforcement across the country to justify warrantless home entries on little more than suspicion. That would reshape not just Fourth Amendment law, but the balance of privacy, safety, and gun rights for years to come. At the end of the day, Case versus Montana is about more than legal doctrines. It's about the boundaries between the citizen and the state, and whether those boundaries can be crossed on nothing more than suspicion. Let's be clear, nobody argues against genuine emergencies. If someone's life is at immediate risk, officers already have the authority to act under long-standing exigent circumstances. But that wasn't what happened in Montana. Police had time, they had options, and they still chose to go in without a warrant. That raises a deeper question. When officials bypass the Constitution out of convenience, what protection do we really have left? From a gun owner's perspective, the stakes are even sharper. If courts allow suspicion to replace probable cause, then every firearm inside your home could become vulnerable to seizure during these so-called caretaking intrusions. And history tells us that once a lower standard is accepted, it rarely gets rolled back. The founders didn't write the Fourth Amendment as a guideline. They wrote it as a wall. Critics of Robinson and Coniglia might say these cases tie law enforcement's hands. But the truth is, the Constitution was designed to tie the government's hands when it comes to invading the home. That's not a flaw, that's the point. So the question is whether the Supreme Court will reinforce that wall or chip away at it. If they stand firm, the ruling could reaffirm the home as a fortress of individual rights. If they falter, it could set a precedent that weakens both the Fourth and the Second Amendments in one stroke. And for millions of Americans, that outcome would hit far closer to home than any abstract legal theory. So here's where things stand. Case vs. Montana is set for oral arguments on October 15th, and the Supreme Court now has the chance to draw a clear line between suspicion and probable cause. It's not just about one man in Montana. It's about the limits of government power, the sanctity of your home, and the firearms you keep there. This decision could either fortify constitutional protections or water them down. And whichever way the court rules, the impact will reach far beyond the courtroom, straight into the living rooms, gun safes, and front doors of millions of Americans. We'll keep following this case closely and bring you updates as it develops. But now we want to hear from you. Should suspicion ever be enough to justify a warrantless entry into someone's home? Or should the Fourth Amendment remain an iron wall that requires probable cause? No exceptions. Drop your thoughts in the comments below. And as always, make sure you like, subscribe, and share this with fellow gun owners who care about their rights. Stay informed, stay engaged, and most importantly, stay sharp.